I feel like maybe you're going to pay $3,000 a month or $4,000 a month. And then you go to court and they're ordered to pay $7,000 a month. And you're like, holy cow, like it makes you feel bad, but you're put on the spot to give them some idea because they just keep pushing you and pushing you, right?
Oh,
I don't commit, but they won't stop. They keep pushing you for a number and you try to do your best,
Yeah,
and
absolutely. And I'm going to recalibrate your schedule there. A month in the family court is tomorrow. I mean, I never get something the next week unless it's the gravest situation with an order shortening time. These events for our clients are epic typically. I mean, so for them, this is a once in a lifetime, hopefully thing, and it's epic. But the judges, they see, they've seen the most horrible things. For them, this is just another case.
Well, if clients come to me, obviously, and the case is already going, I mean, from what we've all talked about here, we can't switch the judge. And so you have to have that conversation with them. But I actually put in my contract that if I find that it's in the client's best interest to switch judges, that they will do it, because there's a $450 fee associated with it. And I tell people, I know it's a lot of money, but you're going to have this judge either until your child's 18.
Alex here with a perspectives video on the topic of how can I help you, the limits of a family law attorney. Let's start off with a round of introductions. Over to Monica Caffaratti.
Thank you. Thank you for inviting me here today. My name is Monica Caffaratti. I am a family law attorney at MJ Caffaratti Law in Reno, Nevada. And Reno is in Washoe County, which is in the, in the 2nd Judicial District Court.
Okay, over to Denise Gallagher.
Good afternoon. Thanks for inviting me as well, Mr. Falcone. I am a sole practitioner family law attorney in the 8th Judicial District, which is Clark County, Nevada. I've been licensed since 1996. I have been doing all kinds of family law, from dependency, abuse and neglect, regular family law. And I think I've appeared in front of every family court judge by now. So thank you for inviting me.
Okay, we're happy to have you. Over to Mr. Blau.
For sure, every family lawyer, Denise, every family court judge. It's Robert Blau. Good afternoon, Alex. I am a family partner at Nevada Defense Group. I run the family division there. I've been licensed since 2009. I'm in the 8th Judicial District in Las Vegas. I too have appeared, done many trials in front of all the family courts, and I feel very conversant and comfortable in talking about family law topics with you today, and I'm happy that you invited me. Thank you.
Very good. I am actually hoping that this is, I don't know about you guys, but I get a lot of what I call frequently asked questions, and videos like this, which is what I hope for it to be for you all, it's one of the great ways to answer questions that you get all of the time from people that you really just can't help them with in the area of family law, because the question goes outside of the boundaries of what you can do as a family law attorney. I suppose we could start off with Monica Caffaratti on the number one most frustrating question that you get from your clients, in the sense of it's really not within the parameters of what you do.
Well, I would have to say, why is he or why is she doing this? People are people, and I can't control them. People have autonomy. Their actions obviously will be made clear in court and will affect their case or could affect their case, but I can't make them stop doing things. And so I think people get frustrated with that. And so setting expectations is very important.
Right. And then I assume that they just don't understand that you really can't control the other litigant. And I guess we can go into Denise Gallagher's example and how perhaps we can add in there how it could impact their attorney fees that they're paying you.
Yeah, I think that, as she said, setting expectations of people in a lot of areas is really smart as a family law attorney. First of all, we are not, even though we're called counselors, we're not counselors. And I think a lot of litigants want to discuss their emotional issues with us. And, it's a fine line to walk, because family law cases are emotional. But at the same time, I try to set that boundary with my clients up front and let them know I'm not a counselor. I think maybe you need to get some counseling to help you deal with the scenario. And if you're going to continue to call me, you're going to find that your bill is going to be really, really high at the end of the month when you're calling me about his child support is 10 minutes late, or I'm super upset that he just sent me a text message about my the color of my shirt, or some things that really are better discussed with a counselor than your lawyer, because then at the end of the month your retainer is gone and I haven't provided you with any useful information in that area. So those are frustrating scenarios.
And over to Mr. Blau for anything additional, as well as maybe adding in maybe what you do to redirect them.
Well, I will say, in continuing with what Monica said, I sometimes am forced to tell clients, I don't have a magic wand. I can't make him or her love the children. I can't make them be better spouses. I can't make them do that. I don't have that ability. Again, and I have said there is a lot of hand-holding. I think I'm summarizing what Denise said. If you want to call me every 10 minutes to talk about things that I can't do anything about, your bill is going to be higher, and I will not have provided you with the service that I otherwise can provide you through the court. So I do find that frustrating. One of the biggest disconnects that I find that I can't do anything about is when one spouse cheats on the other, and they expect some kind of of approval or acknowledgement by the court that one person has acted in what they would consider an immoral way that would breach the trust. Obviously, the courts don't want to hear that. We do have no fault. Ideally, we don't really even want the government to make decisions about who's acting morally and who's not. But nonetheless, if you're hurt, like Denise said, it's a very emotional area. It's very difficult, especially when you've got one party was taken by surprise and is disappointed in what's happened. So it becomes very difficult like that. And that disconnect between the behavior of the parties and the relative objectivity of, for instance, community property distribution is a big disconnect, I find, for people.
Don't you think the disconnect is even bigger when you've got a client who probably is going to be on the hook to pay alimony and attorney's fees? And the wife, I'm assuming, of course, seems sexist, but I'm assuming it's the man who's going to pay alimony and attorney's fees, because men do generally make more money than women. And the wife has cheated on him. And to try to explain to him that even though this is bad behavior, he feels she's going to be rewarded by getting alimony and attorney's fees. And they always say, but isn't she going to have to pay for what she did to me? And that's the disconnect, right, Bob? I mean, it is.
Yep. Not in this court. She may pay somewhere else. Morally, right. She may pay a price, but the courts are not going to consider that behavior. It's going to have no impact. It potentially, of course, could have some kind of impact depending on how bad the behavior was on custody. Depending on how promiscuous, I suppose, if there's strange men or women coming into the house, would have an impact on the health and safety of the child. That'd be one thing. But you're 100% right. And especially if a man gets cheated on, if a woman betrays that trust, and then he has to pay her. And a lot of times people will say, I would pay for the child. I would pay school for the child. I'd pay for the supplies rather than give her the money or him the money. Of course, that's not what the law requires. And of course, the law does not require that child support be actually spent on the child. There's no limitations or restrictions with what the party receiving the child support can do with it. So that is a disconnect as well, and that's a frustrating area.
It makes me want to jump to Monica Caffaratti on two very specific things you mentioned, because even I get those kinds of questions, and I'm not an attorney. As number one, do you have the same issue, Monica, on your clients expecting to get some kind of accounting or ledger from the ex on the child support? And then also another very common frustration, even apparent to me, is wanting to limit who the ex has a relationship with, who they marry, who their roommates are, stuff like that. If you want to elaborate on that kind of issue that you have up in Reno.
So regarding child support, I don't really get a lot of requests for an accounting of what the other parent is spending it on. It's more just complaints. I provide child support and now I've got to pay for half of this, or my child comes to me and needs a jacket. That's what child support's for. So having to explain to clients how that works is, another expectation setting that we're required to do as family law practitioners. Right. So I have to have a conversation with my clients, excuse me, a lot about how they have a right to privacy, and so does the other parent. If safety concerns come into play, then we can, get into more of who's in the household with the other person, but they do have a right to privacy. Now, if the other parent starts dating someone or marries someone, of course, you have a right to know who that person is and who's around your child, but it is a fine line. So I do set that expectation as well. Regarding third-party pickups, usually it will be a girlfriend or a boyfriend that I have the most complaints about. And believe it or not, adults, they make faces at each other. It's just really immature behavior. And so in those cases, I'll have to specifically request that third parties not be involved. And so that's kind of how we can deal with that. And then I also wanted to kind of flip what I said at the beginning, where I had to set expectations for client and why are they doing this? I also have to set expectations for my clients because they will engage in behavior that I will learn about subsequently, and I will tell them, don't do that again, and they won't listen to me. So I have to make it very clear that if you are going to continue in this behavior, then it's going to impact your case, or it could impact your case. And so I think the theme, I guess, that I'm going with here today is client expectation, but it's very important to set those at the beginning.
So for Denise Gallagher on this particular question, it's going to have to do with getting advice from not you, but from all of their friends on what should be happening in their case, and frustration from your client on why the outcome is not consistent with what all of their family members are telling them the outcome should be. Go ahead. I mean, it's
the
common.
most interesting ones, the best ones are when your client is talking to somebody who got like divorced in a different jurisdiction. And they got, college expenses for their kids and lifetime alimony. And, so I'm licensed to practice in Illinois, California, and Nevada. And I actually practiced in Illinois for several years at a really big family law firm in Chicago. And I was just flabbergasted at the law in Illinois. I mean, the court can make you pay your child's college expenses, and they have equitable distribution there. So they can do an unequal division of property in favor of the lesser earning spouse. And I actually had a client who was an older lady who kept telling me that about her friend's divorce, and some bells were ringing. And I found out this lady got divorced in Wisconsin, and my client had completely unrealistic expectations about what she was going to get here. But of course they had a complete different set of laws there, but there's probably no more fact specific area of the law than family law. I mean, every single case is different, from how old are the kids? How long have you been married? Whether you have a college degree, what is your work history? How much money does your spouse make? Did you stay home with the kids? And so every case is different, and people can't see those differences, and they just want to always compare what they got in their divorce to what their friends are getting. Or on the flip side, what they're paying in their divorce compared to what their friends are paying. I mean, I've had some pretty big alimony awards lately. I've had some clients who've made a lot of money, men who've made a lot of money, and the alimony awards ranged from $5,000 a month to $9,000 a month. And then I had another judge who did 35% of the net income. So even from judge to judge in a judicial district court, especially in alimony, we don't have any real guidance on what judges are going to do. I mean, do you find that hard for the two of you when you've got a high earning client to try to tell them how much alimony they're going to pay? It's so difficult, right?
Exactly. That is a question I get, is how much alimony will I get, or how much will I pay? And like you said, there's so many factors to be taken into consideration. And even between the judges with their discretion, that is just no way to say. You can give, your best guidance, but that's about all you can do until you go through the case and actually present it and get the ruling.
And you feel horrible when you have, I shout out a number, and say, look, this is kind of how I feel. I feel like maybe you're going to pay $3,000 a month or $4,000 a month. And then you go to court and they're ordered to pay $7,000 a month. And you're like, holy cow, like it makes you feel bad, but you're put on the spot to give them some idea, because they just keep pushing you, right?
Right.
And when you give them the number, it's not going to be exactly what it is. So it's difficult.
And you recall, Denise, years ago, they tried to at least come up with the Tonopop formula to plug in some numbers to get some kind of ballpark for spousal support. But as both learned attorney says, there's so many factors that go into spousal support in Nevada. And of course, even in 150, it's a non-exclusive list. So there's really any number of factors, any number of reasons. And now, you know, you've also got to take into consideration now with NAC, which is somewhat altered and take, at least in the way that it's taken away statutory caps, although obviously the numbers get small, the percentages get smaller, you do have to interplay between child support and spousal support if the case with minor children too. So it does make it difficult to predict, to tell clients, I think this is what's going to happen. This is what's likely to happen. I've learned not to commit to
Oh, I
ideas
know.
like that.
I don't commit, but you know, they won't stop. They keep pushing you for a number and you try to do your best, you know, and it's not easy. And yeah, you're right, with child support not having a cap and these folks paying much more in child support than they were under the old laws, it's reducing spousal support awards. The cases though where there are no minor children, the spousal awards to me have gotten bigger. I don't know if you guys agree with that. When I first started practicing, I didn't have a lot of cases where people making 200,000 were paying 6,000 a month in alimony. And I feel like they have gotten bigger as the new judges have come in. For the most part, we have a couple of judges who are not very woman friendly, I feel like. And all of our new judges are women. So that says something, but I do find that the alimony awards are pretty large these days. So.
And you had that huge tax change in alimony last year, now includable and deductible, I think, or is it the other way around? I forget, but that has been a significant change too. Obviously, we can't give tax advice. We always tell people, unless either one of these other attorneys have that expertise. I don't, but tax consequences has become much more significant for a spousal support award, both for the recipient and the obligor.
Sounds like one of the common issues with giving the courts wide latitude is with the additional flexibility a judge has, so to come inconsistent awards. And I wanted to see if Monica Caffaratti wanted to add on to the expectation of your client for a predictable outcome, which both Denise and Robert talked about. Is, do you have the same sort of issue with your clients on wanting you to give them a prediction on what the outcome is going to be, and the discretion that you have to deal with actually making that very difficult for you? Go ahead.
Oh, absolutely. And I would say that's probably, you know, one of the top questions I get is what's going to happen? How is this going to turn out? And as Denise was saying, it's so fact heavy, and the courts, you know, have discretion over that, and they're all so different that it's really hard to predict. And then even with the same judge, it's hard to predict what a judge is going to do with a different set of facts and in a different case. And so I really just tell the clients, you know, I never know what a judge is going to do. I can say, I would imagine this, but really set the expectation that it could be completely different. So yeah, everybody wants to go into their case knowing everything at the beginning, but family law is just, you have to kind of go through it and step by step and just go through the process and see what happens at the end.
And that unpredictability, by the way, the one answer, if I can jump in, the one way we can get predictability is to settle, is to reach an agreement. Then they know exactly what they're going to get. And I always tell clients that. I always tell them, this is what is likely to happen. That could happen. But I tell people, if we wind up going to trial, there's a 5% chance that we're going to come out of there and say, what the heck just happened? They're not happy. You're not happy. I'm not happy. No one's happy. So, I mean, settlement, at least you know exactly what your responsibilities are and what your rewards are, for lack of a better term.
And I agree. I would just have to jump in there and say, I agree with that, because I do tell my clients that the best way to have control over your case is to, you know, it's just, I don't push them to settle, but to, you know, let them know that it's very serious to go in there and negotiate with your best efforts, because, you know, if it doesn't work out for legitimate reasons and both parties tried, then we can go and take it further and go to trial. However, then you're putting it in the judge's hands. So, you know, I do stress to people how important settlement is, and that it gives them the most control over their case, and to take it seriously.
going to give Robert Blau the first bite at the next one, which is another very frustrating, or it's a question that I frequently get from very frustrated family court litigants, which is the delay, or the what is quick or slow to the mother or father or husband or wife, the family court litigant, is not necessarily what is quick or slow to the judge or the department. I feel like to a judge, a week is quick, a month is medium, and to a client, it's like, why aren't we getting some help right now or tomorrow? It's like they're just that. Let's talk about that disconnect and how often you get frustrated with that kind of scenario where you're just getting like a play-by-play from the client and they're expecting responses from the court rapid fire.
I will absolutely, and I'm going to recalibrate your schedule there. A month in the family court is tomorrow. I mean, I never get something the next week unless it's the gravest situation with an order shortening time. We just had a situation in our office that this was mid-February, and the court set it for March 23rd or March 24th. And I had told the client, the court is taking this seriously because that is a quick turnaround. Of course, to them, they have no idea. The judges have thousands of cases. Family courts, of course, are the most frequently used courts in our state. We just got 6 new departments here. I forget how many are in Reno, but I think you got some more the last go around.
Yes.
We have now 26 family court judges. In addition, we have PPO courts and juvie courts, and it keeps going. So that is a big disconnect. 1 month is a very fast turnaround for the court. I mean, with the judge we just discussed before we started, the trial I had yesterday, she set that back in January. It was March or August. That was my choice for that. And she literally did not have even a half a day. Now things, people settle and things do move around, but that is a huge disconnect because the courts are bureaucratic and slow moving and burdensome, and we have service issues, et cetera, et cetera. So that is a disconnect. But mostly it's due just to the fact that there are thousands and thousands of cases, and they're only human. They have small staff, and how much can they do? How quickly can they go? So that is definitely an area of disconnect.
So we'll go over to Monica Caffaratti, and if you could please touch on the order shortening time, because my understanding is that districts 2 and 8 deal with those order shortening time very differently. Go ahead.
I don't really do a lot of motions for an order to shorten time. The things that I find that need to be taken to the court right away, would be on an emergency basis with an expedited hearing. Other than that, I don't really have a lot of issues that have arisen where we need to give, the other party needs to have less time to respond. And if it would be a waste of time and money to file it, I'm not going to. So I think that, obviously with an emergency hearing, the child has to have the safety or welfare has to be in danger. So it's a little different there, but I don't do a lot of motions for an order to shorten time.
Yeah, my understanding, Monica, is they're way more popular in Clark than they are up there. Go ahead, Denise Gallagher, for your
They're popular, but they're not granted very easily. The most frequent ones that I'm granted are a motion to continue, like especially during COVID. I've had clients who've had COVID. I had COVID. I had to file motions to continue on an order shortening time because trial was in a week or 2 weeks. I've had abduction cases, obviously, where it was an emergency to get a child back. And I had one of those granted by Judge Almassi a couple of months ago. But it has to be a serious emergency for them to grant one. Our clients think everything's an emergency. But,
right.
It's not. And, I tell them that it's, the loss of a substantial amount of money, the loss of a child, a child's been abducted, or we can't meet a deadline because of something out of our control. Those are like the 3 big ones that you would think of. Other than that, they're not getting granted. Do you agree, Rob?
Yeah, certainly people want them for reasons that I will tell them. This court is not going to issue an order shortening time. These events for our clients are epic typically. I mean, these are heaven forbid, these people have to come back to family court more and more with different parties. So for them, this is a once in a lifetime, hopefully, thing, and it's epic. But the judges, they see, they've seen the most horrible things. For them, this is just another case. I'm not suggesting the judges don't get involved and give each case the time and the concern that they need, but they see these issues all the time. I mean, the clients come to us and they say, "You've never heard a situation like this." And I'm thinking in my head, there's about 12 fact scenarios in which we could fit 95% of family court cases in. So the courts see it, and I like Denise said, I think we're better arbiters of what's likely to require an order shortening time and be granted an order shortening time.
Over to Monica Caffaratti, which is, do you have a disconnect on the issue of clients trying to resolve their custody dispute without even using you? For example, by calling CPS, by calling the police department, or any other sort of let's get custody of the child or affect custody of the child without even touching the custody case. Go ahead.
So you mean like going through and calling the police and CPS prior to seeking legal counsel?
I would assume so. Calling CPS to report some kind of abuse and neglect, thinking they're going to get custody that way, or calling the police, stuff like that.
Right.
Nice.
I do deal with mostly police calls, but they're domestic violence situations. And unfortunately, a lot of them, the police don't really resolve the issue. I mean, I don't know what they can do besides separate the parties at that point, but even sometimes they don't do that. Regarding CPS calls, I do have people come to me who have done that. I mean, if they have legitimate concerns, then, it's a fine line, because you don't want the parent to be harassing the other parent, making allegations that aren't true to get custody. But then also, if they have a legitimate concern and they need help, I've had people come to me that are afraid to call CPS because they think it will make them look like they're trying to retaliate. So it's just kind of a lot of hand holding, which I think we've talked about, and, really calming people down, taking a look at what's really going on, and then coming up with the best plan moving forward together. I will say, though, that one of the things, not so much calling the police or CPS prior, but thinking that they can do the case on their own and then going all the way through trial, not really knowing what it entails, and then not getting the outcome they want. And then they come to me to see if I can fix it. And at that point,
Right.
It's too late.
Of course.
So, that's another issue that I think that we can all agree that family law practitioners, it's very frustrating too, because I would say, oh, I wish you would have come to me before this, but, at that point, it's too late.
And when we go to Denise Gallagher on this one, and also kind of want to add in there, is there anything that CPS can do that you can't do in the child custody case directly? Go ahead.
Well, yeah, I mean, they can, so let's say there's one safe parent and there's another parent who's unsafe. They will, I think people think that if they call CPS on the mother of their child, their wife, if they're living separately, that they're going to get the kids taken away. Okay. The only time CPS takes kids away is when there's no safe parent. That's the only time a kid will go to foster care. So let's say mom lives in a filthy house, or mom is out of her mind, or she's trying to kill herself or whatever. What'll happen is they will place with dad and put some kind of a plan in place that mom would have to do A, B, and C to be able to have like unsupervised contact again. So there are times when CPS does do that, and our judges are very heavily reliant on CPS. I mean, do you guys find that if there is a substantiated CPS case, our judges will say, I want the CPS records. They will have counsel take a look at the CPS records, and they will defer to CPS because CPS is actually investigating. Our judges don't investigate. I think that's a big problem with clients, is that they think the judge is actually going to investigate the case. And I say the judge only knows what we tell them, right? And you have to give them information for them to, they're not going to come off the bench and talk to your child. They're not going to go out to the house and inspect it. We have to spoon feed them information. Yeah, maybe. But, sometimes, like Monica said, CPS, if a parent has a legitimate concern, CPS could be their best friend, because we can't get into the other parent's house. I mean, I have one right now where the house is filthy. I have pictures of cat feces all over. The house smells like urine, dirty diapers everywhere. Well, who else is going to go in that house and tell the judge that that's really happening other than CPS? So in a case like that, I tell the client, absolutely call CPS. And it can be very helpful in a custody case. Yes.
All three attorneys, I obviously CPS plays an important role. All three of the attorneys here, we are mandatory reporters, along with a host of other officials. So, CPS, they are the investigators, correct? I do, however, caution clients that, if the health and safety of the children are legitimately a concern, you call CPS or you call Metro. You do what you need to do. But once CPS is involved, they're a very autonomous, powerful organization, and they're not going to listen to me or the parents. They will interview the children without the parents' knowledge. They will go to the school. They will do what they need to do, and their determinations are out of our control. Once there's an active CPS case, the district
Can
court
I interrupt
has
really
to do-
quick? They're not allowed to interview the children without the parents present, just to let you know. They will
seen
do
that
it,
happen.
but it is illegal to do it. So
I
I'm just letting
appreciate
you
that.
know that you can have that, you can actually have that interview quashed because they are not allowed to essentially take, it's akin to an arrest. If they take a child into a room without the parents, they are essentially putting the child under arrest and questioning them without counsel.
I
So
stand corrected,
you
and I
know.
appreciate that, your expertise, because you've had a track, but that has happened. I have seen that happen. That's good to know. I stand corrected. Do not represent myself as a juvie case specialist, but they are an autonomous and powerful organization, and their investigations can take them places where neither party wants necessarily to go. So once you call them, they have the ability to come in and change the entire direction of a case, which sometimes we want them to do, of course.
Right.
Obviously, they play a vital role for protection, but it's controversial. Like, I think that's not a controversial statement to say that CPS sometimes acts in controversial ways.
Agreed. Sometimes they'll substantiate something that I don't think rises to that level. And then there's other cases where I think a parent's behavior is super egregious and they don't substantiate it. So, because there's so many different investigators. I mean, there's probably 100 investigators at CPS and they're all a little different. So you don't know what you're going to get always.
Okay, this time we're going to start with Denise Gallagher. On this one, we see all the time. Do you happen to have a situation where you have a client that loses in court and they think the solution to the problem is to just change the judge? Get a new judge.
All the time. All
Let's
the
talk about that.
time. Oh my
That's a
God.
very big thing that I have seen with non-attorney family court litigants is they think that the solution to their problems is to just change the judge.
Absolutely. Absolutely. And, when you've gotten to that stage, that is not going to happen. The only time that we can change judges is prior to the first contested hearing. And that's where a really experienced family law attorney can be invaluable to a new client, because as Rob said, and I'm sure, Monica, you've been practicing for a number of years, you've probably been in front of every one of your judges up there.
Yes.
And we do get vibes about how judges rule. I mean, are they mother friendly? Are they father friendly? I mean, nobody's hiding anything. I think our male judges are much more mother friendly than our female judges. And it's something that I've noticed a lot as time's gone on. So if I've got a mom who's super dependent on dad for money and she needs spousal support, attorney's fees, she wants primary custody. If I've got a male judge, I'm likely to leave the case there. If I have one of our older judges, a Hoskin, a Duckworth, an Ochoa, a Henderson, I'm likely to leave the case there. If I get one of our new women judges, no disrespect to them, and they are strong women who are educated and work every day, and I think they look at a woman a little differently, as I do.
I'm writing this down.
Rob, do you disagree with me? I mean, are you not finding this?
I do want to hear Monica's answer. I will say that one of the in my opinion, one of the value addeds from an experienced attorney would be that we know these judges and we can predict within certain parameters what someone's likely to do. I mean, to be blunt, if I have a certain judge who's got less hair than I do, and I've got a written parenting agreement, and they've written something, I'm going to tell them, he is not going to let you out. You signed it. We're done. There's nothing to do here unless it's the most egregious circumstance. So knowing for me, value that I add, a real value that I add is being able to tell a client what this judge, I've been before this judge, that I've had hundreds of hearings and dozens of trials, and I know what this person is likely to do and not do. And that's a
Right.
real,
And so
real
just
added
to get
value.
to the meat of what he's talking about, so the peremptory challenge. So the
There we
peremptory challenge is the mechanism by which you can switch a judge. But if you've had a contested hearing, you can't do a peremptory challenge. One family, one judge. You are stuck with that judge until that judge either loses a reelection bid or retires. Sometimes we've had cases where they've been randomly reassigned because of the expansion of the court. But for the most part, the cases still stay with that judge. I mean, I have only had a few that have changed, and that's when we got the 6 new judges. Some of them got reassigned to Judge Mercer, Judge Rochelot, from other departments, but you're stuck with that judge. So you'd better conform your behavior and your expectations to meet that judge. That's what I tell them. So even though you have a judge who may not be very generous with spousal support or may not be a primary custody judge, they're all supposed to be joint custody judges, but I don't think they are. But if you have one of those judges, we have to think about how we're going to present our case differently because we're stuck now. So
I really want to hear Monica Caffaratti's perspective on the peremptory challenge of judge in her district, because you guys have 26 different judges. She has maybe, what, 6 or 7, Monica? Go ahead if you want to go into that.
Right, and they're all women here, so
Wow.
factoring that in, where it does. Well, if clients come to me, obviously, and the case is already going, I mean, from what we've all talked about here, we can't switch the judge, and so you have to have that conversation with them. But I actually put in my contract that if I find that it's in the client's best interest to switch judges, that they will do it, because there's a $450 fee associated with it. And I tell people, I know it's a lot of money, but you're going to have this judge either until your child's 18, till the judge retires, or, another judge is elected or appointed to that department. And so, I know it seems like a lot now, but in the scheme of things, just do it, get it over with, and you'll be much happier. And so generally clients do listen to me on that. And the ones who don't kind of say, I wish I would have listened to you, but nothing I can do about it at that point.
I really want to get into the weeds with Robert Blau on disqualification of judge for bias. Go ahead, if you had something, go ahead.
I just want to add one thing to this conversation, and I agree with what Monica said, and I like that idea of including it in my retainer agreement. But sometimes you will get, because of the nature of the beast, you will a case will be proceeding in a certain way, and then at a critical hearing, you'll get a senior judge or someone else who will come in, and some of the seniors are likely to defer. Others are not. They will make an independent decision, and they could change the direction of the case. So that's an extra monkey wrench that sometimes gets added in. I don't know if you have that up in Reno in the 2nd Judicial District, but we sometimes get that down in the 8th.
We've been starting to use senior judges more and more because the caseload's just getting so.
And you love when you walk in the courtroom and you look up at the bench and you go, oh no, right?
Oh my God.
I know.
Everything I prepared you in the last hour and a half, forget it, all right?
Yeah.
I've heard that there are some situations where attorneys will just routinely motion to reconsider specific senior judges. We're going to do a separate video on senior judges and judges pro tempore, because this is such a rich topic in and of itself. But the technical question I wanted to ask you, Robert Blau, kind of in the same vein of what we've been talking about, is disqualification for bias, and how often a client thinks that a judge is biased because of the ruling. And I don't know if you want to go into that and what bias is, to help them understand that, a judge's determination or ruling, what kind of impact that has on whether there is bias or not, anything like that.
This is a real tough question. First of all, I will admit that my decision, I don't think I've ever, I've thought a judge was unfair and may have it in for my client, but generally it's been based, in my opinion, on behavior that they've observed that I don't think is as important as the court does. Bias in terms of like actual prejudice against a group or a race or a religion, I have not really run into, and I have never challenged a judge on that. I will say that beyond the individual case where I would even consider doing that, I mean, there are implications to my reputation with that judge and maybe with other judges if I go in and say something like that. That's a real serious allegation. I have not done that. I have not seen that. All I can say again is that most of the time, and my clients certainly think that a judge has been biased or unfair, but I would generally point out to them, well, you got a favorable ruling then, and it's only because you didn't follow through, or, you know, if you're 3 days late on your drug test and she considers it dirty, it's not because she doesn't like who you are or you're of Italian heritage or something. It's that you failed to show up for your drug test when you needed to do so. So I have not fortunately run into a situation where I would say that judge is overtly prejudiced or biased against a party. I can't remember having seen that.
I'll let anyone else jump in there, or we can move on. Go ahead.
I have never filed a motion to recuse a judge because of bias, but I do get a lot of clients who ask me whether or not the judge possibly is being bought off by their ex. Do you guys get those
Yeah,
questions?
I need
Like,
proof.
oh,
I need
my,
proof.
my
Talk about that.
ex-husband knows a lot of people, and
Oh, yeah.
I think that maybe, he may know the judge, or he may know someone who knows the judge. And I said, look, I've been doing this a really long time. I mean, I date back to the original 5, and when family court was 5 judges in Las Vegas, and it was Jones, and and so other than him, and God
There's
bless
a
him,
judge. So
there has
can
never
talk
been
about it.
there has never been an accusation against any of our family court judges that they have been on the take, influenced by outside people in their decisions. We've never had those accusations. So I tell people, unless I've heard of it, if I haven't heard of it, it's probably likely not happening. And that they make really good money. And I highly doubt that the $5,000 that you think your ex is throwing at the judge is going to influence his decision when are making, as much money as they're making. So
Possibly ruin their careers for $5 grand,
absolutely,
right?
absolutely.
You have clients like that, Monica, where they tell you, well, I'm concerned my ex is a police officer or a detective, or the dad is a legend. Go ahead, jump into that, because I do see those. I do get a lot of those, and I'm not even a lawyer.
Right. I would say
Yeah.
with police officers, is what I see most of all, is that they don't think they're getting a fair shake because the other party is an officer and they have connections, and nobody has that many connections, at least not in my office, the clients.
We came here to make a video of frequently asked questions on what's, the limits of what you guys can do. And I really think that we pulled it off. If there's anything else that you guys wanted to talk about, I think I missed, let me know now. Otherwise, we'll go into the goodbyes.
That went fast.
Yeah.
No, I
You
think
did
it
a
was
good
great.
job.
And by the way, Mr. Falcone, Lynn sincerely apologizes. She's
Yeah.
been
It's okay.
texting me, and she said, she says that's part of being homeless because she lives in her
Yeah.
RV. But she says,
Yeah.
I pay a fortune for internet and it's not working. So
It's all right.
sorry.
We'll I'm sure the viewers will understand, and we made it work. Go ahead, Robert. I think we cut you off.
No, Lynn had sent me the same text, so I want to echo her apologies. Just generally, sometimes I'm frank with people, and I will tell them, look, the mere fact that you either have to have a judge make determinations about custody, visitation in support of your children, or support and of your spouse and a division of property, and you're in the system, in other words, you're already lost to a degree. There's no real winners in family court. It's not like Apple versus Samsung, where there's a $4 billion judgment here. It's very emotionally taxing on them. Even if you win, generally, you only maintain status quo anyway. Sometimes it's a clear-cut victory and a child gets rescued, quote unquote. But most of the time, it's a nuanced situation here, and it's very difficult. And I tell people, King Solomon for some inherently wise decision on what to do. He's not around. We have definitely flawed laws and flawed judges, and the system is flawed, and we muddle our way through with some assumptions that may or may not be true, and we do the best job we can. And the last thing I'll say is, again, if parents can agree, if parties can agree, there's no need to go to family court. I mean, they're never going to do that. We're busy as we've ever been because there's a lot of marital strife and custodial problems. But if you can gain control of your life and you can cooperate and co-parent, then you can avoid the worst of having to be involved in family court. So cooperation and co-parenting are real important, and I recommend it.
Let's get your goodbye, Monica, and then we'll wrap up. Go ahead.
Thank you for having me here today. And I've enjoyed meeting you, Denise and Robert. And
You too.
Thank you. And I've enjoyed the discussion today. It was really fun. And I hope to be back soon. Thanks for having me.